common. Nichole Fernandes. Fernandez was under 21 years old when the crime in this case took place. That is now established in law. Her classification as a Mattis case by the Massachusetts Supreme Judicial Court confirms it. She was a teenager when she entered the prison system. She was a middle-aged woman when she walked into her first parole hearing in March 2025. In between those two moments, she spent her entire adult life inside a Massachusetts correctional facility. The crime did not happen alone. It happened inside a trailer in Massachusetts in 1997, involving a small group of people and a victim known to at least some of them. The prosecution built its case around what was documented inside that trailer, what was found, what was done, and specifically what Nichole Fernandes said out loud while it was happening. Here is what makes this case particularly disturbing to psychologists and investigators. It is not simply the nature of the crime. It is the language used during it. That documented statement tells you everything the court needed to know about the state of mind of the person making it. And it is the statement the parole board heard read aloud in March 2025. Helena Gardner deserves more than a name in a court file. She was present in that trailer in 1997. She knew at least some of the people around her, and her family have attended every subsequent parole hearing involving the person who killed her. The relationship between Gardner and Fernandes was not that of strangers. The attack was not random. Court records establish the circumstances that brought them into the same space that night, and the prosecution argued throughout trial that what happened was personal, calculated, and sustained. The victim's family attended the March 2025 hearing, testified, and made their position known to a board that now held, for the very first time, the legal power to release Nichole Fernandes. Their testimony was documented. It was clear, and it mattered. 1997, a trailer in Massachusetts. Helena Gardner is present. Nichole Fernandes is present. Others are there. What begins as a confrontation becomes something the prosecution spent years documenting in full. Court records confirm Fernandes made a specific statement during the attack, verified on the record, presented at trial. That statement is 4 words long. The parole board heard it read aloud in March 2025. Court records and the parole board's March 2025 written decision establish what happened inside that trailer. Not in speculation, but in verified fact. Multiple instruments were used. The prosecution documented the sequence: metal rod, fire, scissors, and a sledgehammer. The parole board described the offense as one of the most extreme victim presentations in their files. That is not language they use casually. Court records show that during the attack, Fernandes made a documented statement to Helena Gardner. The statement was, "I'm your worst fear incarnate." That statement was read to the parole board at the March 2025 hearing. The board did not release her. And here is the detail that changes how you understand the Mattis ruling in this specific case. The Massachusetts Supreme Judicial Court said the brain of someone under 21 is not fully formed. What you have to sit with is whether an undeveloped brain makes that statement more understandable, or whether it makes it more chilling. Helena Gardner died from her injuries. The trailer was set on fire after the attack. Another member of the group, Randy Williams, was previously granted parole under the same Mattis ruling. Nichole Fernandes was not. Fernandes was convicted of first-degree murder at Middlesex Superior Court. The sentence was mandatory, life without the possibility of parole. The defense argued psychiatric illness and an unreliable confession. The jury did not accept it. Now here is the 2026 update. January 2024. Commonwealth versus Mattis. Fernandes became eligible for a parole hearing for the first time. March 2025. The board heard her case. The victim's family testified. Fernandes stood before them as a woman who had served over 25 years. The board reviewed the crime, the documented statement, the extreme nature of the offense, and her incarceration record. They denied parole. Review in 3 years. The brain law opened the door. The parole board looked at what was behind it and closed it again. Massachusetts parole denial characterized Fernandes' March 2025 hearing despite Mattis eligibility. Christa Pike's Tennessee case involves scheduled execution. 18 during January 1995 Knoxville incident, she received death sentence in 1996 with September 30th, 2026 execution date set, despite co-defendant Tatterall Shipp's parole eligibility. These cases shift from parole denied to execution scheduled. 2 sentences being rewritten in courtrooms right now in 2026. The final case involves a woman inside since 1990. Her boyfriend fired the weapon. She was the lookout. He was released in 2020. She is still there. Stay with me. 2. Christa Pike. Christa Gale Pike was born March 10, 1976, in Beckley, West Virginia. Court filings document exposure to alcohol in utero, early childhood trauma, repeated sexual victimization beginning when she was very young, suicide attempts in her teens, and dependency on alcohol and marijuana by the age of 12. A childhood that, by 18, had left her without the emotional scaffolding most adults take for granted. By late 1994, she had enrolled at the Knoxville Job Corps, a government program for low-income youth offering vocational training. At the center, she began a relationship with Tatterall Shipp, who was 17. She became jealous of a fellow student, 19-year-old Colleen Slemmer, who she believed was pursuing Shipp. Here is what makes this case particularly significant to the brain law. Everything about Christa Pike's documented history points to exactly the conditions neuroscientists cite when explaining why an 18-year-old brain does not function like a fully matured adult brain. Trauma delays maturation. Substance dependency in adolescence physically alters development. Romantic jealousy in an emotionally dysregulated teenager produces responses that are neurologically different from adult decision-making. Her lawyers made all of these arguments. They are in the court record. The execution date has not moved. Colleen Slemmer was 19. She and Christa Pike lived in the same residential facility, trained in the same building, and moved through the same tight social world every day. Christa Pike believed Slemmer was pursuing Tatterall Shipp. She was wrong, but she was 18, emotionally dysregulated, and operating with a brain every neurologist who has since reviewed her case describes as far from finished. Court records show that Pike and Shipp had, in the days before January 19th, 1995, planned what they intended to do to Colleen Slemmer. The attack was not impulsive, it was arranged. That planning is precisely what the prosecution later used to argue her youth did not reduce her culpability. A third participant, 18-year-old Shadala Peterson, cooperated with prosecutors and received probation. Shipp, 17, could not receive the death penalty. Pike was 18 by 2 months. That 2-month difference is the entire legal basis for the sentencing disparity that now defines this case. January 19, 1995, a deserted corner of the University of Tennessee Agriculture campus near Tyson Park, Knoxville. Colleen Slemmer has been lured there under the pretense of smoking marijuana. Pike is 18. Shipp is 17. Peterson is 18. What happens next is documented in Pike's own confession, physical evidence recovered at the scene, and in something found on Christa Pike's person after her arrest. That item is what the prosecution built its entire capital case around. Colleen Slemmer was lured to that location and did not leave it alive. Court records establish the attack was sustained and premeditated. Slemmer died at the scene. Following her death, a piece of her skull was recovered from Christa Pike's possession at the time of her arrest. The prosecution presented this as evidence of the deliberate and extreme nature of what Pike had done. Court records show that in her confession, Pike described what happened that night in detail. She did not dispute her presence, her participation, or the outcome. Her defense was not innocence. It was that her background, mental health history, and Shipp's influence should weigh heavily on the sentencing decision. The jury reached their verdict in a few hours, and here is the legal detail at the center of every appeal for the past 20 years. Tatterall Shipp was 2 months younger. He received life with parole eligibility because the law drew its line at 18. He is eligible for release in 2026. She is scheduled for execution in 2026. The brain law says there is no neurological difference between an 18-year-old and a 17-year-old. The state of Tennessee disagrees. Knox County Criminal Court, 1996. The defense argued Pike's youth, her documented trauma, her mental health history, and the role Shipp played in January 19th. The jury convicted her on March 22nd. She was sentenced to death, becoming the youngest woman sentenced to death in the United States in the modern era. In 2023, her attorneys filed a motion using the Tennessee Supreme Court's ruling in State versus Booker, which found mandatory life without parole for juveniles unconstitutional, arguing the same brain science should protect Pike as an 18-year-old. Knox County Judge Scott Green dismissed it. His ruling was final. Booker applied only to juvenile offenders, not legal adults. The distinction was 2 months of age. Now here is the 2026 update. September 30th, 2025. The Tennessee Supreme Court issued a death warrant. Execution date set September 30th, 2026, January 2026. Pike filed a lawsuit challenging the lethal injection protocol, citing a rare blood cancer diagnosis, thrombocytosis, arguing the single-drug pentobarbital protocol would cause her extraordinary medical suffering given her condition. If executed, Pike will be the first woman put to death in Tennessee in over 200 years, and the only person executed in the state for a crime committed at 18 in the modern death penalty era. Her co-defendant, Tatterall Shipp, is eligible for parole in 2026. Scheduled execution distinguishes Pike's Knox County status. Samantha Bachynski's Michigan case involves active resentencing proceedings, 19 during February 2006 incidents across 8 days. She received mandatory life without parole with Macomb County prosecutors, confirming in January 2026 they will not seek LWOP under Michigan Supreme Court's April 2025. Ruling 3. Samantha Bachynski. Samantha Bachynski was 19 years old when she accompanied her then 27-year-old boyfriend, Patrick Selepak, on what court records describe as an 8-day violent crime spree across southeastern Michigan in 2006. The prosecution argued throughout her trial that she was a willing and active participant in every event of those 8 days. The defense, across multiple post-conviction proceedings, including a federal habeas corpus review in 2015, pointed to the age gap, the documented power dynamic between a 19-year-old woman and a 27-year-old man with an extreme history of violence, and the degree to which Bachynski was able or unable to exercise independent judgment in that relationship. Court records from the habeas proceedings lay out the charges in full: 2 counts of first-degree murder, first-degree home invasion, and possession of a firearm during the commission of a felony, kidnapping, and assault on a pregnant woman, intentionally causing miscarriage or stillbirth, and several other serious offenses. This is not a narrow case. Here is what makes Samantha Bachynski's case particularly significant to researchers studying emerging adult sentencing. It is the age gap. The same brain science that tells courts a 19-year-old is more susceptible to peer pressure and less able to resist the influence of dominant, controlling personalities also tells them that an 8-year age difference in a relationship where one party has a documented extreme history of violence is a material factor in culpability. The Michigan Supreme Court agreed with that reasoning in April 2025. The prosecutors in Macomb County reviewed her case and decided not to seek life without parole at resentencing. 3 victims, 2 separate events, 8 days. Scott Barrels, 27, and Melissa Barrels, 27, a married couple in New Baltimore, Michigan. Selepak had cultivated a friendship with them deliberately. Court records document what was done to Scott Barrels using bleach injected into his body. The prosecution used this as evidence of extreme premeditation and total control. Bachynski was present throughout. 5 days later, on the home of Winfield Fred Johnson Jr., 52, near Flint. He had befriended the couple. He was killed in his own home. A pregnant woman was also assaulted during the same period. That victim survived. Her child did not. Court records show that Selepak pleaded guilty to all 3 murders and stated in his plea that the first 2 killings were planned in advance. Bachynski did not confess. She was convicted after trial on the prosecution's argument that she had aided and abetted across all the charged conduct. She was 19 years old from the first day to the last. 2006, Southeastern Michigan. 8 days. Selepak is 27. Bachynski is 19. 3 people will die. Court records from the first murder establish that Selepak tortured 1 victim before killing him, using a substance injected directly into his body. Bachynski was present. The legal question at her resentencing is not whether any of this happened. It is whether a 19-year-old brain, found by the Michigan Supreme Court in April 2025 to be neurologically indistinguishable from a teenager's, could have meaningfully resisted what Selepak directed. 2006. New Baltimore, Michigan. The Barrels' home. Scott and Melissa Barrels were killed in their own house by Selepak, with Bachynski present. Court records document the nature of the attack on Scott Barrels. The prosecution used it at trial as proof of deliberate premeditation and the exercise of total control. 5 days later, Winfield Johnson Jr., 52 years old, who had made the mistake of befriending Patrick Selepak, was killed in his own home near Flint. In the same period, a pregnant woman was assaulted. The child was lost. Court records show that Patrick Selepak confessed to all 3 murders and stated in his guilty plea that the first 2 killings had been planned in advance. Bachynski did not confess. She was convicted after trial on the prosecution's case that she had aided and abetted throughout the full 8-day period. She was 19 years old from the first day to the last. And here is the detail from the 2026 resentencing process that changes the entire legal picture. Macomb County prosecutors have filed their position with the court. They are not seeking life without parole. Under the Michigan Supreme Court's April 2025 ruling in People v. Taylor, this means Samantha Bachynski will be resentenced to a term of years. She will eventually face a parole board. That process is happening right now. Trial at Macomb County Circuit Court, October 2006. Bachynski denied the murder charges. The jury convicted her on all counts. She was sentenced to life without the possibility of parole. She also received concurrent terms of 23 to 75 years for the killing of Winfield Johnson and 18 to 50 years for carjacking and robbery. The federal habeas review in 2015 raised multiple concerns about the original proceedings, but ultimately denied relief. The defense's argument about Bachynski's relationship with Celipak and the limits of her independent judgment at 19 are documented in those proceedings in full. Now here is the 2026 update. The most directly active resentencing process across all 7 cases in this video. April 2025, People v. Taylor. The Michigan Supreme Court rules that mandatory life without parole for 19 and 20-year-olds is unconstitutional under the Michigan State Constitution. The ruling applies retroactively. Bachynski, 19 at the time of every crime she was convicted of, is immediately eligible for resentencing. January 2026. Macomb County resentencing proceedings begin. Prosecutors confirm they are not seeking LWOP. The outcome, a term of years with eventual parole eligibility, is the most likely result. Celipak, who was 27 at the time of the crimes and confessed to all 3 murders, remains on life without parole. The brain law does not apply to him. He was too old. Ongoing resentencing defines Bachynski's Macomb County case. Christine Alexander's Massachusetts conviction resulted in release. 20 during 1989 Hull incidents. She served 35 years before December 2024 parole grants under Mattis ruling covering anyone under 21 at offense. Case 5 involves a TikTok influencer, a car chase at 100 miles per hour, a 911 call recorded in the seconds before impact, and a UK Court of Appeal ruling in October 2025 that cited her age and immaturity as explicit grounds to reduce her sentence. What time is it where you're watching this right now? And where in the world are you? Drop both answers in the comments below. The brain law looks completely different depending on where you are sitting. In Michigan, it is actively reshaping murder sentences as you watch this. In Tennessee, a court rejected it, and an execution date stands. In the UK, it reduced a murder sentence in October 2025. In Canada, the conversation is just beginning. Where you are determines whether this law applies to anyone near you. Drop it below. 4. Christine Alexander. Christine Alexander is a trans woman who was 20 years old in 1989 when she was convicted of first-degree murder in Massachusetts and sentenced to life without the possibility of parole. Mandatory. No judicial discretion, no exception. She has been incarcerated since 1989. 35 years. She entered the Massachusetts prison system at 20 and walked out in her mid-50s. A trans woman navigating 4 decades inside a system that was not built for her, without a single legal avenue for release, until January 2024. Here is what makes her case particularly significant in the context of the Mattis ruling. It did not change her crime. It did not revisit the evidence or declare what she did acceptable. What it changed was the law's position on whether the brain of a 20-year-old is the same as the brain of a fully formed adult. The Massachusetts Supreme Judicial Court reviewed Neuroscience, considered 17 amicus briefs from neurologists, and ruled that it is not. The parole board agreed. The victim was a woman in Hull, Massachusetts, who was pregnant with Christine Alexander's child at the time of her death in 1989. The relationship was intimate. This was not a stranger. So when she died, two people died: the woman Alexander had been with and the unborn child that was also Alexander's. Court records show that Christine Alexander was convicted by a Massachusetts jury of first-degree murder. The cause of death was manual strangulation. The prosecution established that Alexander was aware of the pregnancy. The jury convicted. The trial court imposed the mandatory sentence: life without parole, no exceptions. The parole board had to hold the weight of those two deaths in December 2024. They weighed it. They were granted parole, 1989, Hull, Massachusetts. Christine Alexander is 20 years old. The woman she is in a relationship with is pregnant with Alexander's child. What happens that year results in 2 deaths and 1 life sentence. 35 years later, the Massachusetts Parole Board was asked to decide whether the person who left that apartment in 1989 is the same person who stood before them in December 2024. Their answer was no. 1989, Hull, Massachusetts. The victim was killed by strangulation. Court records confirm Alexander's presence and involvement. The prosecution argued at trial that the killing was deliberate, that at 20 years old, Christine Alexander made a choice, understood what it meant, and followed through. That argument succeeded. The jury convicted. The mandatory sentence was applied. Alexander entered the system and began what would become a 35-year incarceration. Court records show the prosecution's case rested on establishing that Alexander, at 20, had the capacity to form the intent to kill. That argument succeeded with the jury. The defense position at the time of the original trial did not. The conviction stood through every appeal that followed. So here is the part where the Mattis ruling changed completely. In January 2024, the Massachusetts Supreme Judicial Court did not ask whether Christine Alexander had the capacity to form intent. Science does not dispute that. What the court asked was whether the brain of a 20-year-old is the same as a fully matured adult brain, whether a mandatory sentence treating them as equivalent is constitutional. The answer, in a 4-3 decision, was no. Convicted of first-degree murder, life without parole, mandatory, no discretion, no alternative, 35 years served. Now here is the 2026 update, and this is the only case in this video where the brain law did not just change the sentence, it opened the door, and the door opened. January 11th, 2024. Commonwealth versus Mattis. Massachusetts becomes the first state in the U.S. to categorically ban life without parole for anyone under 21 at the time of their crime. Both mandatory and discretionary, both gone. Christine Alexander, convicted at 20 in 1989, is immediately eligible for a parole hearing. December 19th, 2024. The Massachusetts Parole Board grants her parole. She is one of 8 people paroled in the first Mattis wave and the only named woman. She will serve parole in a long-term residential program. As of 2026, Christine Alexander is on parole. 35 years served for a crime committed at 20. The parole board has since granted parole to 21 of the first 24 Mattis cases it heard, a rate generating significant backlash from prosecutors and victims' families across the state. Parole grant defines Alexander's current status following 35 years served. Mahek Bukhari's England case involved appellate sentence reduction. 22 during February 2022, Leicestershire. A 46 incident, she received life minimum 31 years in September 2023 with October 2025. Court of Appeal reducing term to 26 years, citing inadequate consideration of immaturity. 5. Mahek Bukhari. Mahek Bukhari was born in 1999 in New York to British Pakistani parents and grew up in Stoke-on-Trent, Staffordshire. She dropped out of university to pursue a social media career under the name Maybe. Approximately 126,000 TikTok followers, 43,000 on Instagram. Fashion, lifestyle, beauty. Nothing in any of it looked anything like the A46 at 1 in the morning. Her mother, Ansreen Bukhari, moved in the same influencer circles. That overlap placed Ansreen in contact with the person whose threats would set the chain of events in motion. At sentencing, Judge Timothy Spencer KC addressed Mahek directly. His words are on the public record. TikTok and Instagram lie at the heart of this case. That is why you dropped out of university. Had you not done so, you would have been a young graduate with your whole life in front of you, but now you consign yourself to prison for all of your best years. Here is what makes this case significant to the brain law argument. Mahek Bukhari had no prior criminal history. No cautions, no convictions. What happened on the A46 in February 2022 was the first violent act of her documented life. The UK Court of Appeal in October 2025 found that the original judge gave insufficient weight to that fact and to her age of 22. Saqib Hussain was 21 years old, from Banbury, Oxfordshire. He had entered a relationship with Ansreen Bukhari. When Ansreen tried to end it, Hussain threatened to release explicit material he held of her unless she paid him £3,000. Court records confirm those threats escalated in the hours before February 11th, 2022. The Court of Appeal later found those threats to be a mitigating factor the original sentence had not adequately reflected. Mohammed Hashim Ijazuddin was 21. He was Hussein's friend. He had no involvement in the blackmail. He was in that car because Hussein was his friend. In the final seconds of the chase, Hussein called 911. The transcript is on the court record. "They're trying to kill me. They're ramming us. I'm begging you. I'm going to die." That call was still connected when the collision occurred. February 11th, 2022. The A46 dual carriageway, Leicestershire. After 1 a.m., two vehicles are pursuing a Skoda Fabia. Forensic analysis would later establish at least one car reached speeds of 100 miles per hour. Saqib Hussain is inside the Skoda, on the phone to 911. That call was still active when the Skoda struck the central reservation. Mahek and Ansreen Bukhari, along with associates, arranged to meet Hussein and Ijazuddin at a Tesco car park in Hamilton, Leicester, ostensibly to return the money. The moment Hussein and Ijazuddin realized what was happening and tried to flee, two cars driven by associates began pursuing them. The chase reached speeds exceeding 100 miles per hour. The Skoda struck the central reservation on the A46, split in two on impact, and caught fire. Both occupants died at the scene. Court records show the 911 call was played in full to the jury at Leicester Crown Court. The transcript includes, "There's guys following me, they've got balaclavas on, and they're trying to kill me." That call was still connected when the collision occurred. Mahek and Ansreen were convicted of murder. Two associates were also convicted of murder, three others convicted of manslaughter. September 1st, 2023, life, minimum 31 years and 8 months, Judge Timothy Spencer K.C. found her social media fame had made her utterly self-obsessed and oblivious to the damage you do. Now here is the October 2025 update. The Court of Appeal found the original sentence manifestly excessive. Lord Justice Warby ruled, "The judge did not make enough allowance for the fact that this appellant was an immature 22-year-old at the time of these offenses." Her minimum was reduced to 26 years and 285 days. Victims' families responded with documented public anger. The case reignited national debate across the UK about how youth and immaturity should be weighted against the gravity of what was done. As of 2026, Mahek Bukhari is 25 years old, currently incarcerated. Parole eligibility under the reduced minimum falls approximately in 2050. Court-ordered reduction characterizes Bukhari's October 2025 outcome. Jo Pender's Indiana case involves prosecutorial support for resentencing. 21 during October 2000 Indianapolis incident. She received 110 years in 2002, with original prosecutor Larry Sells submitting written support for December 2025. Resentencing petition denied by Judge Snyder in January 2026. 6. Jo Pender. Jo Pender was 21 years old in October 2000 when Andrew Cataldi and Tricia Nordman were shot dead in the Indianapolis home they shared with her and her boyfriend Richard Hull. Hull confessed to pulling the trigger on both of them. Pender admitted to purchasing the gun, helping Hull dispose of the bodies, and staying with him rather than calling police. She stated in court over 20 years later, "After he committed these murders, I did not call the police, but instead stayed with him out of love, fear, loyalty, and sheer stupidity." She has maintained for 25 years that she did not plan or participate in the shootings themselves. At her December 2025 resentencing hearing, she addressed the court directly, her voice shaking. "Today is one of the biggest days of my life because I'm asking for the chance to be free and not die in prison." Here is what makes this case significant in the context of the brain law. Her attorneys explicitly cited her age of 21 as a mitigating factor at that December hearing. The same argument that freed Christine Alexander in Massachusetts. The same reasoning that reduced Mahek Bukhari's sentence in England. Judge Snyder heard it. He denied it. No reasoning was provided. Andrew Cataldi was 25. Tricia Nordman was 26. They were Pender's roommates, sharing the Indianapolis home with her and Hull. The prosecution argued she was the architect, the mastermind who had planned the killings and manipulated Hull into carrying them out. Marion County Prosecutor Larry Sells called her the female Charles Manson at the original trial in 2002. Court records show that the primary evidence against Pender at trial was a letter she allegedly wrote to Hull taking responsibility for directing the killings. Hull subsequently submitted a signed affidavit stating the letter was forged, written by a fellow inmate at Hull's direction in exchange for protection on the prison block. The court, at Hull's own resentencing, treated that affidavit as evidence of further misconduct on his part. It made his situation worse. It did not help Pender. October 2000, Indianapolis, Indiana. Andrew Cataldi and Tricia Nordman were shot and killed in the home they all shared. Hull confessed to both killings and took a plea deal. 75 years combined. Pender maintained she had not planned them, had not directed them, and had not been present when they were carried out. The prosecution's case rested on the forged letter, testimony from a fellow inmate named Floyd Pennington who later recanted, and the argument that Pender's psychological influence over Hull was the driving force behind 2 deaths. And here is the detail that stops this case from being simple in either direction. The man who put Jo Pender in prison stood up for her at the December 2025 hearing. Larry Sells submitted a written statement to Judge Snyder in support of her resentencing. He has said publicly he now believes reasonable doubt exists as to her culpability. The judge read every word of that statement and still said no. Marion Superior Court, August 2002. Convicted on 2 counts of murder. Sentenced to 110 years, 45 years for each murder plus 20 years consecutive. The habeas petition was dismissed in 2008. Then came the prison escape. August 2008, Pender walked out of the Rockville Correctional Facility with the help of a prison officer. 4 months on the run before capture in Chicago. 5 years in solitary confinement as a result. That escape is now the subject of the 3-part Hulu docuseries Girl on the Run: The Hunt for America's Most Wanted Woman, released February 19, 2026. Now here is the 2026 update, December 5, 2025. Resentencing hearing before Marion County Superior Court Judge James Snyder. Pender's attorney cited her age of 21 as an explicit mitigating factor. Larry Sells submitted written support. A documentary filmmaker testified. Her parents testified. The victims' families testified against. January 5, 2026. Judge Snyder formally denied the petition for sentence modification. No reasoning provided. Pender's earliest possible release remains January 12, 2054. She will be 97 years old if she serves the full sentence. Resentencing denial in January 2026 defines Pender's current Marion County status. Barbara Hernandez's Michigan case involves 35 years served, 16 during May 1990. Pontiac incident, she received mandatory life without parole with March 2024 commutation denied. And April 2025, Michigan Supreme Court ruling covering 19 to 20 cohort, not applicable to her earlier Miller resentencing. 7. Barbara Hernandez. Barbara Hernandez was born in 1974. She was 16 years old and 2 months past her 16th birthday when the events of Mother's Day weekend 1990 took place in Pontiac, Michigan. She had been in a relationship with James Hyde since junior high school. He was 20. Court records and her own testimony describe a relationship defined by coercion, physical violence, and sexual abuse, one in which by 1990, Hyde exercised substantial control over what she did and where she went. She had no prior criminal record. Here is what makes Barbara Hernandez's case the most legally and morally complex entry in this video. The brain law argument accepted by the Michigan Supreme Court in April 2025 applies completely and directly to her circumstances. She was 16, younger than the 19 and 20-year-olds the ruling covers. And the ruling still does not help her. She was already resentenced under Miller versus Alabama as a juvenile. The new Michigan ruling covers a different cohort, older than her. The law that freed hundreds of people in Michigan has not reached Barbara Hernandez. James Cottling was 28 years old, a mechanic from Pontiac, Michigan, engaged to be married. He told his fiancée he was going out to buy a Mother's Day card. He did not come home. Court records show that Hyde had developed a plan in which Hernandez, who he was coercing into sex work, would bring a man to an abandoned house under the pretense of prostitution, and Hyde would rob him. Hernandez brought Cottling to the location. Hyde attacked and killed him. Hernandez was present. She did not carry out the attack. The prosecution charged her with felony murder, the legal doctrine that anyone who participates in a felony is fully responsible for any resulting death, regardless of who caused it. Cottling's family opposed Hernandez's commutation in March 2024. Their grief is real. James Cottling was going to buy a Mother's Day card. Mother's Day weekend, 1990. An abandoned house in Pontiac. Hernandez brought Cottling to the location where Hyde was waiting. Hyde killed him. Hernandez was present and did not intervene. When police found them, Hernandez and Hyde were in Codling's car. Hyde confessed to the killing. Hernandez was interrogated without an attorney present for 3 days. She was 16 years old. 72 hours without legal representation. She eventually gave a statement the prosecution used at trial. Court records show that a key prosecution witness, Richard Monday, later recanted his testimony. Monday told the Associated Press, "My memory right now is that she had no role in even touching the guy. Why I testified to that, who knows? That recantation has never resulted in a retrial." And here is the detail that reframes everything else in this video. James Hyde was 16 at the time he killed James Codling. He was resentenced under Miller versus Alabama and released on parole in 2020. The man who physically committed the killing walked out of prison 6 years ago. Barbara Hernandez, 16 years old, present, not the one who did it, interrogated for 3 days without a lawyer, is still inside. Convicted at a Pontiac, Michigan trial in 1991, tried as an adult, sentenced to mandatory life without the possibility of parole under the felony murder rule. No discretion, no consideration of her age, her background, or the role of James Hyde's coercion. Mandatory. At her Miller resentencing hearing following the U.S. Supreme Court's ruling, the court considered all 5 required Miller factors: her chronological age and its hallmark features of immaturity, her family environment, the circumstances of the offense, her role compared to Hyde's, and her potential for rehabilitation. The court found the first 2 factors in her favor. It then weighed her documented misconduct tickets during incarceration, 17 between the ages of 23 and 33, and found them indicative of deeply rooted behavior rather than youthful impulsivity. The court resentenced her to discretionary life without parole. The appeals court affirmed. Now here is the 2026 update, and it is the one that defines what the brain law can and cannot do. March 2024. Michigan commutation denied. Despite documented rehabilitation, the support of prison staff, advocacy groups with years of documented evidence, and 35 years of incarceration for a crime she did not directly commit, the Michigan Department of Corrections secretary declined to support the petition. The commutation was denied. April 2025. People versus Taylor. Michigan Supreme Court rules mandatory LWOP unconstitutional for 19 and 20-year-olds. Barbara Hernandez was 16. The ruling does not apply to her case. She was already resentenced under Miller. She was already covered by that ruling. The new ruling covers a different cohort, older than her. The brain law has rewritten the sentences of nearly 600 people in Michigan who were between 19 and 20 at the time of their crimes. It has not reached her. As of 2026, Barbara Hernandez is approximately 50 years old. She has been in custody since she was 16 years old. She has now spent more of her life inside a prison than outside one. Her case remains open for future commutation applications. The next one has not been filed yet. 7 women, 7 ages, 7 different outcomes from the same piece of science. Barbara Hernandez. Inside since she was 16, the brain law does not apply to her cohort. Commutation denied. Sarah Jo Pender. Resentencing denied January 2026. Earliest release 2054. The man who convicted her now says he was wrong. Mahek Bukhari. Sentence reduced October 2025. Immaturity at 22 explicitly cited by the Court of Appeal, still inside. Christine Alexander, on parole right now, freed December 2024 after 35 years. Samantha Bachynski, Resentencing underway in 2026. Prosecutors not seeking LWOP. The brain law reshaping her sentence in real time. Christa Pike. Execution scheduled September 30th, 2026. 2 months older than her co-defendant, who is eligible for parole. Nichole Fernandes. Parole denied. March 2025. The Mattis ruling opened the door and the board closed it. I asked earlier what time it was and where you were watching from. I want to ask again, because I genuinely read those threads. Drop your location and time in the comments. And while you are down there, tell me which of these 7 cases you think the brain law should apply to, and which one it should not. Here's the question, the honest one. The science is not in dispute. Courts in Michigan, Massachusetts, and the United Kingdom have built it into law. So is the brain law justice, or is it the law deciding that certain crimes were never really the person's fault? Drop your answer below. If this is your first time here, subscribe. Like this video. Share this video. Until next time.